So now on to question number 2, case study number 5 here. Was Brenda properly prepared to tackle this project?
No.
No, definitely not. And you know, if we haven't gone through this coursework, we're not spending tons of time talking about rehabbing houses or all the nuances of, house flipping or whatever. No time for that. What advice should she have been given by Bob? So if Bob's her broker, what should he have been telling her? Right, so have an inspection done, and or get more contractors' opinions on specific items if you need cost estimates or whatever, even if you don't rely on them for their regulated expertise in what needs to be done. If you want to know what it's going to cost to renovate something, they're going to be a better arbiter of that, because now you've got a free estimate if they give you a free estimate. What else? Okay, put yourself in Bob's shoes, and you're going to behave appropriately. Excited, enthusiastic, naive Brenda comes to you and wants to see this house. What other kinds of things would you suggest to her or somebody like her who wants to get into house flipping?
Doesn't he have some degree of, I don't know if I want liability, but responsibility to let her know kind of what she's looking at financially?
Yeah, I
Not
think that's true.
exactly, but to a degree.
No, I think that's true. A lot of people who get into flipping, that's not their main thing. This example, what else does she have? She's got a job, and her job all of a sudden goes into overdrive, and you know what this is like. Everybody in the room's probably been through this at some time where you're like, oh my God, I can't even keep up with my job in my basic life. Meantime, you got a house that's, that's half started, and how are you gonna finish it? So sure, the risks. I think a broker needs to advise somebody, the risks are you start this project and you get a big negative cash flow, and you need to be prepared with how you're going to deal with it. So if somebody says, oh, I don't worry, I got $30,000 saved. Well, that's okay. If you can, $30,000 gives you the money to pay the contractors, but you can't forget, you still got to also escrow or set aside money for taxes and insurance, and you got to be making at least interest, if not principal and interest payments, or be prepared to if the thing drags out a little bit. And then what about a contingency? What about if you open it up and there's some additional problem? I mean, all you have to do is watch some house flipping shows, and you can see this kind of thing, that stuff just doesn't go the way you expect it to go. Even some of the simpler room remodeling shows, just as something as simple as peeling up the existing flooring, and what was underneath not what we expected to find. So how do you deal with it? Well, one way is to spend more money. If you don't have it as an option, then what are you going to do? So that's, again, an area where you don't have to have any experience necessarily, but expertise is usually a hard-won bit of expertise in an area like this. I would think that if you're going to work with investors, you would want also for yourself to have taken some additional coursework or additional training of any kind to just learn more about numbers and risk and things, and teach yourself scripts you're going to need to convey this. There's a one-day course offered, I think it's through the CCIM Institute, that is all about sort of residential investing and sort of thing. So I mean, a course like that might only cost $100 or whatever. I think it makes sense for a broker to take it and then keep the materials handy. Or for $35, you can go to Barnes & Noble or Amazon.com and get a fix it and flip it workbook and textbook together, and something at least runs you through a series of notes. Watching flipping shows is not a bad thing to do either, although they're long on story and short on detail in some cases. But there's a lot of risk. I mean, I have a lot of experience in this, and there's a reason I don't spend a lot of time doing it. I don't think there's as much money to be made. And don't even get me started on all the house flipping gurus who are all over the TV and radio again. People drive me crazy. Maybe it's just me. Maybe I'm just jealous of their apparent phenomenal wealth, but I'm just convinced that they're just trying to mislead people left and right.
That they're doing 6 weeks.
Yeah,
2 weeks.
yeah. Come to our seminar and you'll get all the money you could possibly stand to find all these great deals that somehow nobody else recognizes are there. Please. All right, so anyway, Bob should have been a better and more conscientious advisor. Next question, why are brokers licensed?
To protect the consumer.
Yeah, protect consumers from people like Bob, who apparently is just interested in making a sale. And there are people like that in your industry, so watch out for them and don't become one of them. Who's the state trying to protect? Obviously, the state's trying to protect Brenda and every other non-licensee. All right, so that's number 2. Number 3, Brenda lists her house with Patrice. I don't know, this is the same house are we talking about, I guess? A home inspection reveals several serious defects, including lead-based paint and high levels of radon, which will cost several thousands of dollars to fix. Brenda's attorney recommends that Brenda disclose this on the seller disclosure form. The property is now much more difficult to market and will be sold for much less than Brenda paid. Brenda is upside down. She owes more than her house is worth. The lender is threatening to sue for the deficiency if they lose money at the closing. What are Brenda's options? Yeah, sue Bob.
Can she plead with the bank?
Yeah, definitely. That's what you do in a short sale. So she has 3 options there. She can do it directly. She can pay her attorney to do it. That'll cost several $1,000s. The hope is that if he or she is successful, that those several $1,000s will actually come out of the lender's pocket, because all she's looking to do is walk away with no, residual debt. Or 3, have the broker, have Patrice do that negotiation with the lender.
Does the lender have any responsibility to seeing that she has enough money to take care of this?
No.
Not at all?
Other than the fact that she would have been pre-approved based on her income, that doesn't seem to have been a problem here,
Yeah.
right? I mean, if anything, she should be getting lots of extra overtime because she's working all those hours.
Wouldn't the bank have required some kind of an appraisal of the house worth at the time that she bought it?
Sure.
And how can it be so much less now?
Well, because it's got problems that an appraiser wouldn't have uncovered.
Appraisers not aware of lead or radon testing?
I mean, they're aware that they exist, but they're not. It's not their problem whether somebody does it or not. An appraiser will appraise a house, taking those into account if they're given to them or they're made known of them. But that's not an appraiser's role. An appraiser's role is to appraise the property based on that, for that particular purpose, on that particular date, based upon the data that's been given to them or is available to them. And lead paint testing, radon testing, any other home inspection results are not made available to an appraiser. Any other options besides suing Bob the broker or negotiating with the lender to see if there's anything they could do on a short sale? Even if the lender agrees to take something less, what's the other component part that's addressed here that needs to be dealt with besides just immediately being able to get out from underneath it because the lender will take 5, 10, 20, 30 grand less? What's the other part in here that's really hanging over her head? It's related to that. What is the lender threatening to do? Sue for the deficiency. So whoever negotiates with the lender needs to get that waived. It makes little sense for her in the long term to get out from underneath this place unless the deficiency goes away also. Because now she won't have the property, yet she's still going to have that debt obligation. So getting that deficiency waived is an important thing. That's one of the most important things that having an attorney, a good short sale, experienced real estate attorney can do. They know how to negotiate that and get that waived.
If Brenda has a job, why would they write off the deficiency? I could see if they were never gonna get paid anyway.
Well, because that's what they're looking at. They're looking at, she has her own house, presumably this is a second home, and so she's just not making payments or not making enough payments. Maybe the payments are $800 and she's making $450 a month or whatever. So they're just gonna get farther and farther upside down. Bank's experience is that the longer you hold a distressed property, the bigger the losses get to be. better to cut bait, if you will. Get back what you can, put that capital back to work. It's like, you know, hardest thing I imagine for some surgeons to do is decide, you know, do we amputate or try and continue to treat, because gangrene just gets worse, you know, infections just get farther up the limb. And that's what this kind of thing is, financially speaking, of course. You're just talking about, you know, let's just get rid of this and get our money back. Now, that may change in 5 years, Steve. You know, we've got this climate of lenders are used to kind of turning these things off to get them off their books, to get them out of the way. Lenders were very reluctant and difficult to deal with prior to about 2008, 2009, until they realized they didn't have a choice, because there was this cascade of properties that were going to come down on their head. And but the norm for lenders, you know, so, which I'm assuming we're going to end up going back to in a few years, is that they don't really want to deal with these at all. So you guys may see this in, you know, a few years in, that all of a sudden the switch is flipped and you can't negotiate short sales with lenders anymore. They have so few losses left that they'd rather let the thing go to foreclosure, get what they can, keep the deficiency right. Pretty soon, the federal government's not going to continue to renew this Debt Forgiveness Relief Act either. And debt forgiveness under a short sale is also going to end up going back to being taxable income. Once there's few enough people to protect, it'll go back to the way it was, I presume. I think that's what we'll see. My dealings with lenders in the past was very complex, very odd even, but it's only been the last 6-7 years that they've really become accomplished at turning large volumes of loss, because anything else would be worse. So here's a couple of other notes that the publishers have. Brenda should consult a HUD counselor about the option available for refinancing or modifying the existing mortgage. I don't know what happens when you're underwater like that. Maybe if it's an FHA loan. It's not something that I've been through with anybody, so I don't really know, but that's in a note here that there are housing counselors, debt relief firms that deal with this kind of thing, that sort of thing. Maybe they would have other ideas. For me, I would look at it as a short sale candidate and trying to get that deficiency waived. It's the only part of it that I would really understand. Number 4, the house was appraised when Brenda applied for her mortgage. Should the appraiser have noted all the repairs in the report? I think that's what Steve asked earlier. So my answer there was, I wouldn't expect it. If the reports were available and given to the appraiser, then that could be appended. You pay a little more for that appraisal because there's more work to be done. Brenda claims she never saw the appraisal. What do you think about that? How can you have an appraisal on a house that somebody buys and the buyer never sees the appraisal? How does that work?
Does it work like a home inspection? The person that pays for it gets it?
Yeah, the client is the person who pays. So the client of the appraiser really is who?
Bank.
The bank. Now there are laws today that the Consumer Financial Protection Bureau, if I have that right, and laws and regulations that they've put into effect, that I think you now have to provide the appraisal to the buyer. But that's relatively new. That wasn't the case in the past. So most buyers, or many buyers rather, would oftentimes not see their appraisal.
It almost seems fraudulent on the bank's part that they got this appraisal, Brenda never saw it. They knew it was distressed. This poor woman steps in, doesn't really know what she's doing.
Well, she's already involved. You know, she wants to do that. She's the one who makes the decision first. She's the one who says, you know, this is what I want to do, and the bank's just reacting to that. It's just not their problem, unless it's for a risk avoidance issue, and then it's more of an internal controls problem for the bank than it is a third-party liability problem.
If she closed though, technically she would have paid for the appraisal, so.
Right, but the appraisal still runs to the lender.
Right, but if she paid for it, the lender has to provide it.
Well, they do now, but they didn't necessarily a few years ago. I mean, it's pretty much under just newer rules that it's required. There have been a lot of loan programs in the past where you didn't have to have it at all. And maybe that's been longer than 5-6 years. I don't know. I can't remember. But today I agree that's true. You can't, since Dodd-Frank, we can't not have a consumer see the appraisal. And there's a time frame for that, right? I think there's a time frame within which it has to be given to them.
It has to be, well, for us, it's 3 days prior to closing.
Before closing, right, yeah. Yeah, no, that's it, that's exactly what it is. I just couldn't remember if it was 3 or 5. And I think we covered some of that stuff in chapter 23 maybe, in that last text. There's like 3 things, the 3 time frames toward the end of that chapter that show up in the bigger text we look at. So, yeah, so it kind of depends upon when this took place. If this took place before Dodd-Frank, that was common. Today, she should have seen it. In that regard, then her lender has culpability. Does Brenda have a claim with the appraiser? Again, my opinion is no, unless he was given the list, in which case, then maybe yes. Should she report the appraiser to the state appraisal board? Good Lord, we're going to be reporting everybody to everything here pretty soon. Again, I think it all depends upon whether the appraiser knew of those reports. Then it should have been included. Again, even then, if the appraiser is supposed to, do a simple appraisal, they may require a higher fee if they've got to do a lot of extra work. Number 5, Bob, the broker, is working with Brenda as a buyer. What are Bob's responsibilities to disclose his role as a designated agent?
It's a dual agent to start with, isn't it?
That's confusing, isn't it? They don't address it that way in any of the answers, but in the text, it starts off by saying, showing some of his listings, right? So if you make that assumption, which is a reasonable assumption to make, in my opinion, from the way it's written, then he has dual agency responsibility. But the answers don't say that. So I suspect that what's happening here is he's just acting as a buyer's agent. It just sounds like, it's his listing. I don't know. So it's a little confusing based on where the answer key is. So yeah, so designated agency still has to be disclosed, right? I mean, you still have that obligation. It has to be disclosed in writing. And dual agency is what it appears to be from that bit of the text. Question number 6 says, is he a dual agent? My answer key says he's acting as a single agent, but the text makes it sound the other way around. If he does not make the disclosures that he's supposed to make, this is question number 6. What recourse does Brenda have? I guess you could turn him in. Haven't talked about turning anybody in for 30 seconds. Turn him in. Looks like a movie, Hang 'em High. We'll just call it Turn him in. That's what'll be the story. Or when in doubt, turn them over to IDFPR.
Well, they kind of painted a pretty bad picture.
Well, that's what case studies do, right?
So it sounds like,
they make it messy and then want you to try and sort through all these things.
I don't know, if he was that bad, and then he just wasn't even working for the guy anymore because of his practices. So it made him sound like he was pretty bad. So I don't know what I would do. Normally I wouldn't turn anybody in, but.
Yeah, bad agents
Make
do.
me mad.
Bad agents do exist, and you may run across them from time to time. I have just learned for myself not to sort of jump and go to IDFPR right away. Every once in a while, when I talk to the other agent, it's like, oh, it's not quite what I seemed. Or in talking to them, they're horrified. You thought what? This appears like it's what? And they'll make an immediate correction and change. So in the few times when I have approached another agent or their broker directly, nothing I have ever done professionally has ever had to go any farther than that. Now, I've sat on grievance panels and the arbitration and grievance professional standards board and the grievance panel. I can't remember the name of the 2 committees all of a sudden, with the local realtor association. So I mean, I've been involved in cases and looking at things at a kind of an association level, which is where a lot of disputes, including consumer complaints, can end up, rather than in courts or at IDFPR. And you get some strange things that just make no sense and for which there's little to no excuse, other than people get busy or something like that. Rarely do you really see somebody who's this bad. But when you read the disciplinary actions, You can see it once a month or so. You just look at it and you go, really, how could somebody possibly do this? So there are people who, they're desperate, or they get into the business specifically with the intent of taking advantage of people. So, yeah, talk to your broker and figure out what the proper course of action is. Turning somebody in might be the most reasonable thing to do at some time. Any other questions or comments about number 5 at all? Let's look at Unit 6 case study. Emma, the real estate broker, has several listings, and she's working with many buyers. She's successful. Her managing broker is happy with her. Potential buyer walks in and asks about one of her listings. Can you please give me information about it? It seems like it could be perfect for me and my wife. Goes to set up the showing, blah, blah, blah. Then we get into an offer and some negotiation, and then everything goes south from there. Question number 1, could the Smiths report Emma to the state licensing agency? And if they are going to, what are they reporting her for exactly? It's in the last couple of paragraphs there.
Well, I think she didn't present the second offer,
Right.
so that's wrong.
Right, that's an important thing to remember. Again, common test fodder. All offers get presented. Even if you're under contract, you get an offer, you call your client and tell them about it. Again, let them say, no, dummy, I don't want any more offers, we're under contract. That's their prerogative, but they need to know that it's there. If they tell you don't bother, then put a note on it, stick it in the file, let the other agent know the sellers aren't interested. They're gonna let the first what's current play out. Keep in mind, this is off topic for the course, but on topic for the subject matter. Local MLS rule gives co-op agents the right to present their own offers. So if your client does say to you orally, yeah, we don't need to see any other offers, this one we got is solid, we're confident it's gonna go through, and you report that back to the other buyer, they may say, well, did you present it to the other agent? And if you say, I told them over the phone, they may say, I want it presented in writing, or I want to present it in person. They have the right to do that. You don't have the right to say no. Your client does, but you have, by MLS rule, have to get that waiver of presentation in writing so that you can send it off to the other agent and say, here's where my client signed off and don't want it presented. In a market like we have now, where inventory is thin, you can tend to sometimes get testy buyers agents because they're frustrated. Second day a property's on the market, they show it, they call you up to tell you they got an offer, and you say, we already had 3 offers, we negotiated one that's been under contract for 6 hours. That can happen to them week in and week out with the same client, and they just get frustrated, and that's where you might get some pushback. I want proof that your client doesn't want to see my offer. So again, they could report her for not presenting the offer. How about for her sponsoring broker? Like the third time we've talked about this the last hour and a half. What do you think? Better or worse than fair housing, or than, what was the last one? Just bad brokerage practice. I think this fits in there somewhere. I mean, again, it's the sponsoring broker potentially has liability, training and policy and procedures, and why doesn't she know that she's supposed to present this? So the best answer to that question, I think, is they could have the same liability as Emma. Sanction won't be termination, but could be civil penalty. That would be fairly common. Training. Question 2, can the Smiths back out of the contract they signed because they feel deceived? So they're under contract, right? but they only knew about the one offer. So that's what they finished up and went to contract with. Now you got this other offer that's out there. Let's say that the other offer is significantly and obviously better, so that you can see the Smiths would feel like they have a financial incentive to get out from underneath the first deal. Can they use poor broker performance, substandard performance in terms of not presenting in a timely way this other offer? Can they use that as an excuse to get out from underneath their otherwise contractual obligation to sell the house to that first buyer? Go ahead.
I just think that it's no different than accepting the offer than seeing another offer come in and say, wow, I wish I would've waited or something like that. I don't think they're hurt in any way. I mean, it's unethical, yeah, but they were given an offer and they accepted it. I think they have to live with it.
Anybody else?
Well, I think that the Smiths didn't have the opportunity to counteroffer. I mean, they say it was significantly less, but they don't give a dollar amount, they don't give a dollar amount of what the other people offered. So
Well, let's say that the other offer would have been better. Let's say that they didn't know about an offer that could have turned out to be better, whether it was through counter-offering or whatever. Let's just say that logically we could prove that the other deal might have turned out to be a better deal, but they weren't informed of it in a timely way, for whatever reason. Ignorance, stupidity.
Well, the agent didn't do her job by presenting all offers.
Right, but does that give the sellers the right to kill their current contract?
I think so, because the contract is void if it's not done properly, isn't it?
Well, what does that mean, done
Well,
properly?
she didn't fulfill her obligations.
But is she party to the contract? See, that's part of what the deal is here, right? The agent failed in her duty, but why should that adversely affect the first buyer, who's not party to any kind of negligence or inappropriate action? They just showed up, made an offer, negotiated the deal, and are starting to plan their lives revolving around that contract. See, this is one of the things that courts look at, is how are the parties affected here, right? So the proper course of action in a case like this is to discipline or fine or otherwise take action against the agent independently of the deal, and the deal probably, and I say probably because I don't really know, right? We don't have all the facts, we don't know how a specific judge might rule, but or how certain clauses like attorney review periods or whatever might allow somebody to get out in some other manner, but I think the deal sticks. Because I think relative to the contract, the lack of presentation is irrelevant. It's a separate tangential kind of issue. It matters to the Smiths, but because you've got this innocent third party in there, the court's probably not gonna disadvantage them for a problem that they were unaware of or didn't participate in creating. One of life's great inequities. Question number.
Smiths can they claim that they potentially lost money?
Sure. Yeah, they could sue their agent. I mean, they could sue her for damages.
What would it be like the $25,000 max?
Well, those are civil penalties. Those go to the government. So in this case, they're going to sue for damages. That's different. And then if they can't collect from her, that's when, if they win the judgment, that's when they are going to pursue it through the Real Estate Recovery Fund. So I think they go after Emma and her broker and their insurance policy. If the damages are fairly small, if it's $2,000, $3,000, $4,000, $5,000, maybe the insurance company or the broker should just offer to cough up the money. There's damage control. You can't lose sight of, in all of this stuff, fundamental things like customer service and your company reputation, right? We're talking about legal nuances here, and we're talking about proper procedure as it relates to the regulatory agency and what the license law says. But what about your reputation, right? What is that gonna, I think maybe there's more damage control to be done there. And again, this is more of a decision for a managing broker class to decide, okay, let's create this hypothetical scenario and say that the Smiths are now gonna claim that they lost $3,000 because of your inaction. Well, let's put a dollar amount on the listing, and let's put a dollar amount on the commission. How much of that commission would you give up just to keep them from bashing you online or with everybody that they talk to? How much money would it take for you to go to them and say, you are absolutely right, we handled this completely wrong, we're gonna make it right to you, we're just gonna cut our fee by X? Would you be willing to do that if it was your firm? Would you kind of be out in front like that? Tell your agent, you know, you screwed up, and this is coming out of your share first, and then the rest will come out of our share. I've had that conversation with a sponsored licensee. You didn't handle this right, your commission's being docked by this. I knew I was absolutely categorically right, but that agent, who was an experienced broker and had been managing stuff for a long time, walked out of my office mumbling to every other agent in the office, I can't believe it, I can't believe it. He's docking me, blah, 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 whatever, it was a few $1,000s. The commission was like 38 grand.
Can a sponsoring broker acting as a contractor to each one withhold payment without court action?
From their own licensees?
Yeah, being that they're subcontractor, not employed. Well, actually, they can't do it with their employee at all.
Well, no, it depends upon how your employment agreement reads. If it's, you know, bonus or however else it's described, I think you can, right? If it's bonus money.
That's bonus money.
Yeah, right, and then it's discretionary. And you can make that paragraph read that, you know, your bonus is gonna be X percent so long as all things are followed, handled properly. I don't remember how our contract read, but in this one case, it gave me the right to do that. What it was a mishandling of earnest money. It was a license law violation. It was very clear, and it's something that everybody should have known. And, you know, if he had complained to IDFPR and we'd have gone, at those days it was OBRE, if he'd complained to the state agency and gone before them, I don't know whether we would have won or not, but I just, you know, it was a significant challenge or problem. And, you know, it was whatever, 7%, 6%, less than 6% of his total portion of the fee, but it was a big, I thought it was a major problem. I don't know what happens in those cases. I think it depends upon how your contract reads, and you may have to talk to counsel about how you're gonna handle that. I do not know of cases of complete independent contractor people being dinged, unless there was some agreed upon settlement or something out of the thing. But I wouldn't be asking my agents, I would be telling them and let them push back. If they create a scenario, this is fundamental. And if they take it to court, I'm just gonna ask, on what basis, you know, in what universe do you think you get to keep all the money when you don't do what you're supposed to do? When you violated, you know, your agreement to represent us in a professional manner? Maybe I'm crazy.
Well, I mean, they may withhold that if the person never sues them, there's no damage on their part either.
I agree with that. That's why I'm saying this is something you get out front and negotiate to get resolved. You're negotiating with your agent at the same time and get that, you know, taken care of. That's what I would want to see done. I mean, I would personally, very quickly, without any question, be willing to lose the entire fee to just have the problem go away. Now, the interesting thing about that kind of a case study, if you turn this into that sort of a case study with those sorts of questions, is, well, the damages are $3 grand and the commission is 10. What if the damages are 10 grand and the commission is 10? What if the damages are 20 grand and the commission is 10? You know, your answer might change as you look at different scenarios. How much money are you willing to cough up here to make the problem go away, as opposed to push it to where it might turn into a complaint or litigation or whatever? There's not necessarily a right or wrong answer there. There's just business decisions to make. Question number 3, should Emma have helped Tim fill in the blanks on his offer? We've talked about disclosures so far, right? We've said for the most part, maybe unless you're typing stuff, where, you know, handwriting isn't a giveaway, you're filling in a PDF to that point, but not check boxes or whatever. I think you're probably okay, but for disclosures, otherwise, you shouldn't touch them, right? Those are for the clients to decide, refer them to their attorneys if they really need legal advice. But what about here? What about with a contract form? Can an agent, in this case Emma, help the buyer fill in the blanks of that contract form?
I think the agent usually fills it in.
Yeah, that's exactly what happens, right? I mean, in fact, that's what Quinlan and Tyson case basically says. Agents are allowed to fill in, what we are allowed to do is fill in the blanks of pre-printed contract forms that are commonly used in the area. So hence multi-board contract 6.0 that we just looked at last time. That's the standard contract we talked about it here. You have a copy of it now. You can get trained in your office. You can get trained through the multiple listing service. So you can get trained how to handle that thing. So you see it, you see that contract when you write it, when you receive it as representing a seller. That's the only contract form for residential agents that you're likely to see until it's updated or modernized, or if somebody presents on a 5.0 contract. So that's exactly what you do. Fill in those blanks, line through, or put NA in stuff that doesn't apply until you get to the optional provisions, in which case those things don't have to be put NA. So for the first part, I think the answer is yes. That's what you do. You help your buyers fill them in. You may sitting there on your laptop or your tablet typing the things in today using DocuSign or Adobe PDF reader or whatever. Second part of question number 3, should she have helped write an addendum? What is an addendum? Yeah, right, addendum meaning an addition, right? So it's something added to the contract form. So why can she fill in the blanks of the contract form and she cannot?
Be acting as an attorney.
Right, because at that point in time you're doing more than filling in blanks, you're helping to draft language. The client can write out whatever they want. Clients are entitled to practice law for themselves. They are entitled to be short-sighted. They are entitled to be stupid. All of those are rights that they possess. So they're willing, or they're able and legally to do any of that they want. But you cannot help them in any way, shape, or form, except you might want to say to them, perhaps you should talk to your attorney before you draft this.
Well, this new contract has a place for contingencies, so it's already in the contract.
Well, it has a place for contingencies, right, yeah.
So, I mean, because she's drawing up a contingency, that's what she was doing, I think.
Well, so long as it's for something that's there, I mean, what's the contingencies?
Did the old contracts have contingent places for that?
Yes,
Oh, they did.
but not always, and you have to go back a long way, but it wouldn't have. But here, whatever reason, maybe there's something in addition, maybe there's some other condition, or they're just modifying the language. But you're right, in our standard contract, you shouldn't have to do this. Either way, in Illinois, you cannot do this.
Oh, an addendum for inspection.
Inspection, right. So, I mean, you shouldn't even have to do it, but ignoring the fact that we know a little something about the contract where it's got all those inspection options already in there, looking at it on face value, she just shouldn't be involved in drafting anything like that at all. And I've had those cases come up, rarely, but again, it's Sunday night, 10 o'clock, and they're worried about termites or something else like that, and they want to draft something, and they go, here, you talk good, you write something. No, I can't, I literally lost a client on a $600,000 listing because I wouldn't review his contract for him. Question number 4, was Emma remiss by not having Tim's wife present when the offer was being filled out and accepted? Remiss not being a legal term. I mean, it's not, just, was it dumb to not have her there? Or what do we know about the wife not being there or not having signed the deal?
Does the wife only apply in homestead?
Well, I don't know. What do we know? What are the facts we know here? Are they buying together? If they're both on the note and they're purchasing together, then they both got to sign. So do the facts even tell us?
Buying it for her.
I'll call it both the owners.
Yeah. So it's kind of a nuanced way to address it, but my assumption here is that they're buying this thing together. Obviously, if they are buying it together and she needs to be on the contract and she's not, you've got no contract. I mean, a contract wouldn't be valid if it's meant to be in both their names without her signature. But if his name is the only one that's on it and he's the only one that signs it, he's on the hook by himself, whether he's able to get financing or close or not. So it is the kind of thing you have to kind of line up who the buyers are with who the signatures are. Question 5, assume there was earnest money on the contract. What are Emma's duties regarding this earnest money?
Give it to Bill to hold.
Yeah, give it to whomever's gonna hold it right away, whoever the party is, so they can be put in the escrow account. By what time? How long does he have? By what time?
24 hours.
By the end of the next business day. What is it called? Well, I'll skip it up. The next question is, I think you've already answered that. Is it sufficient for her to keep the earnest money check stapled to the contract, sitting in a file until closing? It's okay to have it there until you have a contract, right? When it's an offer, it should be paper clipped into that file somewhere so you've got it. But as soon as the contract, as soon as that form becomes a contract because the parties have signed it, now the clock is ticking and that check's got to get to wherever it's got to go. Her office, you know, the other office, the title company, whoever is acting as escrow agent needs that money so they can have it deposited by the end of the next business day. Last question, what is it in number 5? What is it called if Emma deposited the earnest money into her own personal account and used it to pay bills? Yeah, I mean, that's what they say here, but actually if she's using the money and can't give it back, it's conversion because she's stolen it. Commingling would be, I think, if it went into the broker's account. Right, Emma's a sponsored licensee, is she not?
So it's conversion.
So I personally think conversion's the better answer, though my answer key does say commingling. Question number 6. What actions could the state licensing agency take against Emma? What are the things that she did wrong? We had the whole, what was the first thing we talked about? The offers, right? This is the one that had, right, where she didn't present the offer. And then the other thing we just talked about, where she helped draft or create the addendum. Both of those things are sanctionable actions. Anything else that anybody noticed?
Isn't she a dual agent in this case too?
Don't remember the fact pattern. Yeah, they don't really tell us that there's another agent, do they? Yeah,
That's what she's
she has a blank offer, you're right. So
Right.
assuming that she handled all the dual agency paperwork correctly, then there's not an issue there, but we don't know that, so if she didn't, then that's sanctionable. We also don't know, it doesn't tell us whether she did all of her designated agency disclosures properly. Well, she would have done it in the listing for the Smiths, but we don't know if she did the designated agency disclosure to Tim and his wife also. So that's a possibility. It's a good catch. Anything else that anybody noticed that's a possibility here? That's all I have. Last question out of the great big yellow book. Try not to be too sad. It's a tough one. Who are the offerors? Be Tim and this is Tim. Assuming she's supposed to have signed the deal in the first place. And who are the offerees? Yep, the Smiths. And then you've got the whole counter-offeror, counter-offeree, when you go back and forth, etc. Questions about any of that or those or whatever at all? So let's talk about Thursday night. So we're in good shape as far as our case studies go. A few things we should walk through Thursday night when we get together. Market analysis, we won't actually do one in full detail, but we'll look at tools that are available to us. Buyer's cash to close exercise, which is relatively straightforward. Again, you're not going to get tested on any math on your final in this course, but you could get this exercise at the state exam, and this is the kind of thing, if you work with buyers, that sometimes they just ask you how much cash is it going to take, what am I going to have to bring to the closing table to close this deal. So we'll walk through that in some form on Thursday night. We'll take a look at the HUD-1 closing statement and the good faith estimate disclosures. We'll talk a little bit about buyer pre-qual and approval, I think which we've talked about already, buyer agency, and maybe more importantly, we'll spend some time, 30, 60 minutes, whatever, I think, maybe more than 60 minutes. We'll see what I can do and weave it in with these things, and we'll go through the multiple listing service together a little bit on Thursday night. So I'll bring that up on the screen. We'll put up with the fan noise from the projector, and we'll look some things up. So if you got some properties you're interested in, or some property you want to look up, bring an address or something like that, and we can scour through and see if we can find stuff like that as we're looking at things. We'll look through some of the standard documents, give you just a sense of how agency works in that environment. And we'll use the tools in the MLS, at least one of them, maybe two of them if I have a chance to look at it. I've never done Cloud CMA, as they call it, but that's another tool for doing a market analysis now. So at a minimum, I'll look up an old CMA I did a couple of years ago and show you that process of doing it either for a seller or for a buyer, and how it's much easier done. The form's already there, how you can customize it, that kind of thing. Again, you won't be tested on any of the MLS related stuff, but it makes sense to see it kind of in context, and then you can have seen it and have a better sense of what all that looks like. So Thursday night should be fun. So if you have time, I think I have a HUD-1 and a good faith estimate posted up online. You can find them online. They may have been in your old book as well. You should just look through those things. Otherwise, not a whole lot of reading, not a whole lot of preparation work for you at this point in time. What I recommend you doing is studying for the state exam. And keeping in mind that we've gone over a wide range of subjects here, and kind of anything in these subjects is grounds for you being tested on. Everything we're doing now is review. Really, it's just taking the subject matter you talked about or learned about in the prior course and putting it into an applied scenario where you then take the knowledge you already have and apply it. So that's the kind of thing you will be tested on in part a week from tonight on your final exam, 28 4 possible answer multiple choice questions. And so the only thing I can tell you for preparing for that at this point in time is to really be thinking as broadly as you would be in prepping for the state exam. There won't be anything completely new. You won't be completely blindsided by any subjects. Everything will have been addressed in some manner, but there's not a comprehensive review in this course like there was in the last one.
Okay, so this test is not on what we did.
Oh yeah, but it's not necessarily going to be, here's
it's gonna be more like our last test.
You're not going to have here's a seller's net sheet, fill it in. You're not going to have a case where you're going to look at the final exam and go, these 6 questions are straight out of case study number 1. I remember going over these exact questions. It will be, for example, let's say if there's a question on a market analysis, for example, it might ask you who does it and when, or a seller's net sheet, who prepares it. Things that by now you should have understood just by us kind of walking through it, the fact that, this is what we do at a listing appointment for a seller. So I would say it's a little bit more nuanced, but then there are also things that could come up that we haven't necessarily addressed in specific, but would come out of the area of materials that we've talked about that you should know even just from the first course. So to some degree, this counts on that. And I do this that way in part here because this is my last best chance to give everybody a sense of where you are in being prepared to go for the state exam. Without giving away the details for what happens a week from tonight, I will tell you that all the students in 4 years that have taken this course have passed except 1. And you have to work, you have to make conscious effort to not get through this course. So a week from tonight, you're here from 6:30 to 9, be prepared to be here for that full time. At the beginning, we may have some other exercises or stuff we're gonna do, but even when you're done with the test, you won't go home. You will go home after I've graded all of them and you know how you did. So I will give you your grades on this final that night. So it's very uncomfortable.
We're not gonna know if we're the second one in 4
You-
years.
Yeah. I remember that circumstance very clearly because I thought, oh crap, I have to tell this person.
I'd rather know online.
So, all right, any other questions that anybody has? So again, prepare for this final by, doing your preparatory work for the state exam along the lines of the subjects that we've been covering here, agency and disclosure and those sorts of things. It'd be good for you to know a week from tonight where you're at without having been spoon-fed questions and answers, I guess is part of what I'm saying, because that's what you need to know going forward. That having been said, you should all still get through it. If you don't have any other questions, have a lovely night. See you back here Thursday at 6:30. Thanks. Thank you.